Kelly and I both saw the story, so we got to get Paul Harding on this. This can't possibly be true. Long story short, though, it looks like this guy a Brooklyn guy was tried and convicted. A jury found him guilty that he shot a rival dead during a dice game, but it looks like his conviction now has been tossed off because his mom couldn't get a seat in the courtroom during jury selection. We got to get some clarification. Paul Harding from Martin Harding Mazzotti is here. Hey, Paul.
Good morning. Good morning.
I mean, this is true.
I wish I could tell you it wasn't true, because as you read that headline, I'm half embarrassed to let you know that is in fact the case.
Wow.
And it was the Court of Appeals, which is our highest court in the land. And as you read the headline, it certainly has that sense that this is unfair and this is the wrong process. But it is clear Sixth Amendment violation. We have Sixth Amendment where people accused shall enjoy a speedy and public trial. And so the public trial, you don't hear about it a lot, but it is as important a constitutional right as a speedy trial, meaning you can't be put in jail and when's the trial going to come? Oh, whenever we get around to it. Speedy trials have to happen. We saw that thing in Rensselaer recently where a case was thrown out on speedy trial grounds, but public trial grounds are just as strong. And in this case, the outcome just appears outrageous as you read the facts.
So she couldn't get a seat in the courtroom during jury selection. So what that says to me is if I'm ever convicted of a crime or accused of a crime, I'm going to pack the courtroom with as many people as I can find and make my mother stand outside the door.
Yeah, well, it would be a good start. But what they're supposed to do is they're supposed to make accommodations. She could stand in the back. They have cameras in other rooms. She could watch it from a camera. They have to make what they call accommodations. And again, you're right, it was just jury selection. As soon as all those jurors, and the reason they couldn't do it, they had all these potential jurors in the room. There was just no seats. As soon as the jurors sort of worked their way through and left, she had a seat before the trial. So it even makes it seem a little odder. But in that situation, what they fear, of course, going back to the Founding Fathers, are these trials that would occur behind closed doors, and all of a sudden your neighbor was gone, convicted, nobody knew about it, and there wasn't the public listening to the trial. It is a fundamental right, but they're supposed to make accommodations here. They didn't, and the case is overturned. Again, it's not that he's not going to be retried, because that's already in the works, but they've got to go through that whole process again.
It just seems weird. I mean, and I understand you don't want trials done behind closed doors, absolutely. Yeah. But I'm wondering, I mean, there must have been other members of the public in the courtroom, right? So just because his mom wasn't there doesn't mean nobody else was there.
That's right, but excluding some is the equivalent of excluding all.
Wow.
It has to be opened, and if the physical place isn't big enough, let's say that you just put me in the OJ case, right?
Right.
But at that point, there were other accommodations made, and family members are an integral part of that.
Hey, we're speaking to our legal analyst, Paul Harding. We have less than a minute left, but Kelly and I were kind of amazed that this David Cassidy DWI thing keeps going on and on and on. But so I guess his attorney was just going to submit his guilty plea, and it'd be all done yesterday, and they realized he's up in Saratoga. So, I mean, what are the rules on whether you actually have to show up in court or not, personally?
Yeah, you have to show up in court. And I read that yesterday. I was kind of scratching my head because, as a general proposition, when you have, a speeding ticket, that can often be done by mail. It's a violation. But when you have a crime, in this case it was a misdemeanor, the charge, it requires an appearance. And the exceptions to that are quite limited. Someone's in the military, someone who lives really far away. By that I mean multiple states away and can't make it. In this case, sure, I guess he does live somewhere else, but he's up at Saratoga. So it struck me funny. Maybe the court didn't know that he was going to be in town. Maybe they're a little bit embarrassed now that they gave him that special exemption. But historically, you're correct. Misdemeanor requires an appearance.
So if you can be there, you should be there.
Well, if you talk about the right to a speedy trial and the part of the person accused, well, does the court have a right to a speedy trial too?
Yeah, there's a situation where they can't delay, the defense can't unnecessarily delay things. But of course, the rights are always going to be lined up, toward the accused. They just are.
All right. Hey, Paul, thank you very much. Good talking to you.
All right, guys. Thank you.
Paul Harding, our legal analyst, 1-800-LAW-1010.